She handles divorce, probate, guardianship, estate planning, real estate, and immigration. She is concurrently pursuing a Doctor of Education in Professional Leadership and Educational Administration at the University of Houston Main Campus. She is a graduate of Master of Laws at the Southern Methodist University Dedman School of Law, located in Dallas, Texas, and Master of Education in Educational Leadership, Administration, and Supervision with Principal Certification at the University of Houston, Victoria. She completed her post-baccalaureate studies in education, generalist at the University of Houston downtown, and she is a graduate of the University of the Philippines and at the University of Cordilleras College of Law. Ladies and gentlemen, our presenter tonight, Attorney Aileen Ligot Dizon.
Thank you for such a very concise introduction. Okay, so let me share my screen with you again here. And let's start from the beginning. Okay. Okay, there. Can you see the entire screen?
Yes.
All right, thank you.
Yes.
Okay. All right, thank you for inviting me to speak to you today about last will and testament. And today we will talk about the 3 learning objectives for this topic. So we will understand the importance of having a will. We will learn about the types of will here in Texas, and we will explore the common errors in making a will. Now, for the other two, the 2 learning objectives, which cover understanding the importance of having a will and exploring the common errors in making a will, that could have a general application, but for the objective on learning about the types of will, that will be just Texas. Okay. So again, our learning objectives, we will understand the importance of having a will. We will learn about the types of will here in Texas, and we will explore the common errors in making a will. All right, so first part, I would like to ask you some questions, and you might have an answer right now. You might not have an answer. So I just want you to think about this. First question I'd like to ask is, what happens if, I would like you to ask yourself is, what happens if I die without a will? So if you have an answer, you can answer this question quickly in your mind. You don't have to share it. I just want you to think about it. The other question is, if I'm married right now, will my spouse get everything? So that's another question that I've been hearing from people who are asking about whether they need to have a will or not. All right, this is another question that may apply to you too. If my spouse and I die at the same time, like for example, you both are driving, you're both in a car and driving going somewhere, which is very common here in the US, and something happened, you both, something happened there and you both pass away. Now, who will take care of your children? Have you thought of that? How about this question? If I'm not married and I don't have any children right now, who will get my property? And this question, what if I am married and I have children? Will it go to my children? Is that automatic? So that's one question. That's a question that I'd like you to think about if you have children. So now that we have, think about those questions. Like I said, you might have answers to those questions. You might not have. If you don't have, don't worry about it. As you listen to this webinar, you might have some answers at the end, and you might have a very good answer, or you might have some things to do to make sure you have a better answer to those. You have better answers to those questions. So really, tonight is just about last will and testament. So let me ask you, what is a will? Now, some of you might already have an idea what a will is. You might have an extensive knowledge about a will if you already talked to an attorney or you already have a will in place. Some of you might not have any idea what a will is or might have a little bit of knowledge about a will. But I assure you that at the end of this webinar, you will know more. And even if you already know a lot about will, you might know something more, and that is important. Now, I will discuss a will in a different way today, not the traditional way that I just give you the definition. So a will is not just any documents. A will is actually a legal document. It is a tool where you can make a decision as to what you want to happen to your estate when you pass away. Meaning to say, you have a voice, and if you're gone in this world, your will will, your last will and testament will speak for you. So it is not just any piece of paper or any document. It's a legal document that has to comply with the requirements of the law in your state. So here in Texas, it's going to be the Texas Estates Code. Can you please mute, because I can't see who's not muted right now.
Bert, paki-mute.
Okay.
Thank you.
All right,
I
thank
do
you.
do that.
Oh, let me, okay, because right now I couldn't see. I'm full screen, so let me figure out who's not. There. Are we good? Okay. All right. So, okay, let's continue. A will is not irrevocable, which means that it can be changed. It is revocable. It's the opposite. It is not a document that is set in stone. It can be changed. It can be amended as long as you are still alive and capacitated. When I say capacitated, what I mean is that you know what's going on. You are, you know what's happening. You know that you are going to amend your will. And just to distinguish, you're still alive, but you're bedridden or you're unconscious. So that makes a difference. So that's why I said that in order for you to revoke your will, you have to be alive and capacitated. Okay. And the next one is, a will is not just about assets and properties. If you're thinking that, oh, it's just about disposing my properties, it's just about dividing my properties and how much part of my asset will go to my children, to my wife. It's not just about assets and properties. As a matter of fact, a will, you can make a decision as to your remains, how to dispose your remains. The other possible thing that you can include in your will is, if you have minor children, you can establish guardians for your children. Could be guardian of the person, guardian of the estate. So you can already establish that one in your will. And it's very important if you have minor children. You can also set testamentary trust in your will if you have an incapacitated beneficiary, or you just simply want to put the estate in a trust, and the trustee will have to distribute your estate later on in accordance to your instruction in your will. So it's not just about assets and properties. There's more that you can do in your will. Remember, it could be the most important document that you will ever sign in your life, because it takes care of your estate once you pass away. So it's very important. Okay, now that we have discussed what a will is, now I want you to answer this question. Why do you need to have a will? Why is it important to have a will? Apart from what we already have said about a will in the previous slide. I want you to think about this, that in a will, you get to decide who gets what of your estate, which means that you can allocate how much part of your estate will go to your spouse, to each one of your children. It might not always be equal division. You might also give general gift. When we say general gift, it's giving some amount of money to a beneficiary. So that is considered general gift. Let's say, for example, I give $10,000 to my nephew, Daniel Smith. Okay, so that is a general gift. You can also give specific bequest or specific gift. When I say specific, we're talking about specific personal items or real property. It could be like, for example, a car. Let's say you have a 2020 Honda Civic car and you want to give that to your niece, Marianne Santos, something like that. I'm just making up names. So I don't know if they exist, but just a disclaimer, I'm just making up names. Okay. Because if you don't do this, if you don't have a will, then you are just telling the state, you know what, Texas, just do whatever. The state of Texas will do the work for you. And that might not be your will. That might not be how you wanted to distribute your estate, but you can't do anything anymore because it's too late. You didn't make your will. You let the state of Texas make a decision. And I was talking about a while ago the legal treats, the video, the 2-minute legal treats that I've been sharing it in public. I talk about how Texas will distribute your estate if you pass away without a will. So, and yes. So another thing that I'd like you to think about, why do you need to have a will, is you get to elect someone to handle your affairs after you pass on. When we say elect someone, I'm talking about executor. You get to name your executor in your will. Why is this important? Remember that the executor will manage your estate. The executor will make sure that your wishes are followed, that your instruction and as to the distribution of your estate is being followed, and that if the estate owes some debts, that they have to be settled. So basically, the executor has complete control of your estate after you pass away. So of course, you definitely would want someone whom you trust to do the work for you. Because legally speaking, if you don't have an executor in your will, or if your executor doesn't want to do the job, anybody can apply as an administrator of your estate. When I say anybody, it could be somebody you don't even know. And of course, it will pass through the qualification requirement of Texas, but it's just anybody who's qualified could be an executor or, administrator of your estate. I'm interchanging the terms executor and administrator because if you have a will, that person is called executor. If you don't have a will, or if the person is not named in a will, then that person is called administrator, just to distinguish the two terms. And that is important because you want somebody whom you trust to handle your estate when you pass away. Okay, and the other reason is that you can spare your loved one from lengthy ordeal with probate matter. And when I say lengthy ordeal, I'm talking about complicated probate cases. And the complication could arise from a lot of factors. It could be the wordings in your will. It could be that if there's no will, then they have to follow the interstate succession here in Texas. And if that is the case, they'll have to find first all your heirs, your legal heirs. And sometimes we have to hire somebody to trace who are your heirs. And it could be very challenging and very costly as well, because sometimes they're everywhere. And we want to make sure that we are able to find the heirs. And that's why it could be lengthy, it could be complicated, depending on your situation. depending on the circumstances of especially your family circumstances. Sometimes your family is too complicated, like there are extended family, you have prior marriages, so it will take a long time to find those heirs if you don't have a will. So you want to spare your loved ones from dealing with this ordeal, then make sure you have a will in place. Okay, and also you can establish, like I've mentioned earlier, you can establish legal guardianship for your minor children if you have minor children, or if you have incapacitated children that have mental health issues. So you can establish that one in your will. You can pick or name the person whom you trust to be the legal guardian of your children. And when I say guardian, there are two types of guardians in Texas: guardian of the person and guardian of the estate. When I say guardian of the person, that guardian takes care of the personal needs of your minor child. Guardian of the estate manages the asset or properties of the child. So, but it could also be the same person as long as that person is qualified to act as both. So yes, you can do that one in your will as well. Okay. So now that you've heard what is a will and why is there a need to have a will, or what can you do in a will, what is your excuse now for not making a will? What is your excuse? If you don't have a will yet, what is your excuse this time? Why is it that you're probably going to think, oh, I'll do that later, not right now. It's not a priority.
Could be costly.
This is, well, we'll talk about that. Now look at this one. Maybe this is what you're thinking about right now. Well, I do not have many assets. And this statements here are based on what I generally hear from clients who are actually consulting about not having a will or having a will or doing estate planning. I hear this a lot. I do not have many assets, attorney, so I think I do not need a will. Am I right? Is this right? No, this is not. This is absolutely wrong, and I'll tell you why. You may have, probably right now, you may be living in an apartment and probably only have a car and some savings in your bank accounts. But what is something, because you'll never know what's going to happen in the future, right? What if, for example, you bought a property in let's say next year or next 2 years, you bought a property, you bought a real property in Texas, and you know that life is so uncertain, right? And something happened to you right after the closing. So legally speaking, you are now the owner of a real property, but you haven't done your will yet because you're thinking that, well, I'll do it once I bought a property, then I'll do it. But something happened before that. Something happened to you before that opportunity come to you to change or to make a will. So what's going to happen to your property? Then you will be considered dying without a will, and therefore your property will be distributed according to the state of Texas. Let me just admit, Mr. Alex Lin. So yes, so that's why I say this is not entirely right. Okay, the other question here is, or statement here is, I set up all my assets to be payable on death to certain persons so I can avoid doing a will. Basically, this person is just avoiding probate. Most of the time, the reason is because they don't want probate because they think it's costly and it takes too long. So they do this. They just assign beneficiaries in their investments, in their properties, like the title of their properties. They create a transfer on death deeds. Is this a good plan? Well, I'm telling you now, maybe, but not entirely. It's not a good idea, in other words. I'm not saying you can't do that one. I'm not saying it's not a good idea to just do this. But what I'm saying here is that Yes, you can do that. That'll give you a peace of mind. There are some benefits to that, but think about this. When you do your transfer on death deeds or assigning a beneficiary in your in a particular account or investment, what if the beneficiary name in that document predeceased you, passed away before you, and you haven't designated a new beneficiary? So that means the proceed of that investment will become part of your estate. And since you don't have a will, then that will be distributed under the law of intestacy, intestate succession. Again, Texas will make a decision what's going to happen to that property. So that is why, yes, you can do that, but always have a backup, always have a will in place to take care of the rest of the residue of your estate that is not disposed under in that document, like there's no designation of beneficiary. Because if there's no beneficiary, then automatically the beneficiary is your estate. So you have to have a will in place for your estate. Okay, and this other question here, other reason here or excuse is, I don't feel like making a will is a priority. Maybe because this person is thinking about, you know what, I'm too young to think about death. I'm too healthy to think about dying. So I'll just do this later, probably when I grow a little bit older or when I have more property. So this person is thinking that, okay, there is a perfect time for making a will. I'm telling you now, this is a big mistake because life is uncertain. No, although it's unfortunate that we know we can't live infinitely, we can't say when you're going to die as well. So let's say thinking that it's not a priority, it's a big mistake. And I'm going to tell you why. In one instance, I have a client whose husband passed away. So she is actually a second wife. So the husband made a will prior to marrying her. And in that will, he designated his children from prior marriage as the beneficiaries. So when the husband married her, the husband already has a will. And then thinking that it's not a priority to update his will, they plan to do it at a certain time because they're busy. They're trying to find a perfect time to do it. But guess what? 3 days before the scheduled meeting with the attorney, the husband didn't wake up, just didn't wake up. I was told that he's healthy. He doesn't have any health issues. He just didn't wake up. And so what happened here now is that they have to probate his estate, and they're going to be presenting and they're going to be probating the will that he made prior to his second marriage. And in that will, the present wife is not existing at that time. So guess what happened? The wife can't get anything under that will. She's not even a beneficiary. She's not even an important person to be notified in a probate hearing. She doesn't know what's going on because they don't have any, the name executor in that will has no legal responsibility or obligation to notify her because she's not considered an heir in that will. So it's sad, but we don't have pretermitted wife here in Texas. It's pretermitted wife is a wife that was not existing at the time the will was made. That usually happen if there's a second marriage. So there's nothing for her to get from under the will. So of course the will only dispose, or the husband, in that will of the husband, he's only disposing his separate property and half of the community property. So half the community property will still belong to the spouse, but she's not going to get anything from the separate property of the husband, or not even the half that the husband owns in the community property here in Texas. So yeah, if you think it's not a priority, well, think again, you'll never know. Just like that example. He was very healthy and he just didn't wake up the next day. And this happened a lot already. I've heard so many stories about pretermitted wife, and it's sad, but that is the law, so we have to follow that. Okay, so we've learned about this. Let me see, this is, okay, I just paused for a little bit, just want to make sure that I have the correct PowerPoint. I'll stop sharing for a little bit. And I'm going to close this one because I think I pulled a incomplete PowerPoint. So just to make sure that I have the necessary information I'd like to share with you, let me just open this other PowerPoint. Okay. And let me share with you again. Okay, let me admit Dorothy and Esteban. Okay, they're joining us now. Okay, I'm gonna be sharing again. Okay, I think we missed this part. Okay, so having talk about what is a will and why is there a need to have a will and why is a will a priority. Now, you don't want to create an issue after you pass away. So creating a will is important to avoid prince-like problems. And what is this prince-like problems we're talking about? You all know probably he's very famous prince. He passed away without a will. So his estate is still being disputed as of this time. Let me just admit some other people still trying to join. And Susan, okay, they're coming in now. Okay. All right, so what happened here? Since Prince did not bother to make a will, he probably had some preparation or some estate planning done, but maybe a will is not a priority. So this is what happened. He died without a will, and his estate has to be settled under the interstate succession law of the state where he is a resident at the time. So what happened here is still being disputed at this time, since he doesn't have a will. So his heirs are his 6 siblings, and it's becoming more complicated because apparently one of the heirs passed away while it's still being settled, and that person assigned or transferred his right in the estate to a different a private entity. And so a lot of people are now claiming to his estate because of all these complexities that happened. Just imagine a brother is supposed to get something from his estate, but that brother, before getting his share, assigned it to somebody else. And then that brother passed away. And so this somebody else is now claiming against his estate. And then the other sister also did the same thing, assigned her part of the estate to somebody. So now there's a lot more people claiming in. And what's happening right now is, of course, since this is dragging a lot, it becomes very costly because there's a lot more court costs and expenses and attorneys' fees. Good for the attorneys, they're earning more. Because it is complicated. So yeah, you want to avoid that. That's why you need to have a will. Okay, and let's go to the next slide. I want to make sure. Okay, we have discussed this already. Okay, as to why we need to have a will. And we also discussed here that really not having many assets, that's not an excuse, because you might purchase a property later on, and then before you make a will, you pass away. And so definitely it will be an interstate succession, and the state of Texas will make the decision, not you. Or you set up your assets to be payable on death, and then all of a sudden your beneficiary in that document pass away, and so the proceed will be part of your estate. And since you don't have a will, then Texas will make the decision for you. And if you don't feel like making a will as a priority, think again, look at what happened to Prince and the pretermitted wife. So those are just some examples why it's important to have a will. So now that we talk about all that, I want to ask you now, maybe you're already thinking, wait a minute, I probably need to have a will now or update my will now. So where do you start? Where do you start? Now, honestly, I think it was Leia who brought it up a while ago. I'm not sure if it's you, but just correct me if I'm wrong, that maybe because probate is costly. Well, honestly, and well, truthfully, somebody is trying to get in. I'm sorry about that. But I don't see the name. So anyway, the real issue here is finding actually not the probate itself, because probate, I'm telling you, is not that costly. Even making a will is not that costly. But you just have to make sure that your will is compliance with the law, with the state law, and it is properly written. As a matter of fact, you can make your own will, and you probably already know that. And we'll talk more about that later as we go to the next learning objective. But right now, the struggle that I've seen so far is actually finding time. Okay, you're probably too busy to think about it, or sit down and write about it, or talk to an attorney and start planning for your will. It's just the time is really what is challenging for most of us. And I understand, because we have a lot of things to do, we have obligations, and we feel like it's not a priority. And maybe motivation. You probably don't have the motivation to do it as of this time. Oh, well, time and motivation. Time, I'm telling you now, the time is now. Now is the time. And just think about Prince. Just think about the pretermitted wife. And it's real, it's happening. And think about tomorrow. Are you certain you're gonna wake up tomorrow? Do you have a peace of mind right now? You think that you have secured your loved ones? Spare them from costly litigation later on? Because really, what if I told you there was no next time? Are you gonna do it now? But who knows? Do you know if there's a next time? Those are the questions I always ask my clients, and then really they think about it, because it's happening, it's real, it's a reality. Life is uncertain. You'll never know. You have families, you have children. You want to make sure that you are prepared if that time comes. Now, motivation. What motivation are you looking for? You have your family. Are they not enough? Your children, are they not enough motivation for you? Heirs, security, the cost of litigation later on, the tax that your estate might have to pay, and of course, what could be more precious than peace of mind? Peace of mind. So are these not enough motivation for you to think about having your will, and not wait for the perfect time, because that perfect time is uncertain. It's probably not even existing. So think about, those are the questions I'd like you to think about as you ponder upon our topic for tonight. So, okay, so here we go, brain check. And you know me, I always make sure that my students are paying attention and listening, because that's what this is for, is to educate you. So I want to make sure that I am successful. So here's the first question. Fill in the blank. If there is a will, there is a, anybody? A way? I knew it. That's why I put that one. If there is a will, then you have a peace of mind, right? Because you know that your loved ones are secured and that your wishes, you're able to write your wishes, your instruction, so that you have a voice even though you already passed away. And that is the purpose of your will. All right, next question. Once you've made your will, you can no longer change it. Is this true or false?
False.
False.
Because like we have said it earlier, a will
It's
is
not
it's not
irrevocable.
Yay, look at you. Not irrevocable, which means that it can be revoked anytime as long as you're alive and capacitated. And by the way, joint will in Texas, I'll talk more about will, but this time is, I think it's a perfect time to talk about joint wills. Also, joint wills are, or joint will is valid here in Texas, but I do not advise that because of this issue on revocability. Because when I say joint will, husband and wife will have just one will together. Now, the problem with that is that if one of you becomes incapacitated, then that will becomes irrevocable, which means you can no longer change that because the other one has to sign too. So that's why I do not recommend joint will. And that is one way when a will in Texas becomes irrevocable. Okay, good. Now, is it true that you can name a guardian for your minor child in your will? True or false?
Yes, true.
Yes.
True, yes. You can actually name guardian of the person and guardian of the estate for your minor children, and not just minor children, but your incapacitated children as well. And also you can establish a testamentary trust in your will for your minor children. Okay, very good. All right, so let's go to the second learning objective, which is not really that, it will not take a long time because there are only 2 types of will in Texas. So this is just Texas. Some other states, they might have more than 2 types of will, but we are just going to be talking about the types of will here in Texas. We know that the will is a legal document where you can actually name an executor for your estate. The person who's going to manage your estate is your executor. You can also name your beneficiaries and allocate how much of your estate will go to certain beneficiaries. And you can establish guardians for your minor in the will. But I just want you to think about this, because a lot of people are doing this and they think it's okay. If I write my wishes down on a piece of paper and sign it, will that qualify as a will? I think my dog said yes. Okay.
Yes, but
Okay.
it needs to be notarized.
Oh, okay. So the answer here is yes, you can write your wishes on any piece of paper. As a matter of fact, you can write it on the back of a receipt or a tissue, napkin, as long as it is in your handwriting, pure handwriting. Okay, and it must be signed by you. And in Texas, that is called the holographic will. Or sometimes you'll see handwritten will. Now, in order for it to be valid, it must be, like I said, in tally in your handwriting, not anybody else. What happens if you downloaded, because I know that some wills can be downloaded, and there is this will that is fillable. I don't know if you encounter that. You downloaded a fillable will. That means you printed it out and you complete it with your handwriting. Now, could that be considered a valid will in Texas? Yes, maybe, but there could be a lot of problems later on that kind of will. First and foremost, the court might just consider what you have handwritten there. So whatever is typed there is not going to be considered, or either way. It could just be the typewritten, and the court will totally ignore your handwriting there. So that is not a good thing, because that could be the will can be invalidated as a whole, or it will not really reflect later on what you really wish for, or it will not follow your instruction as it is, because there is typewritten and there is a part that is handwritten. So yeah, handwritten wills are valid as long as it is signed by you, and it doesn't have to be notarized, and it doesn't have to be witnessed if it's a handwritten will. But don't be too excited about holographic will, because the truth is most of the will contests and wills that are invalidated are holographic wills, and you'll see later on why. Why is it not a good idea? Okay, so we'll talk more about that in next slides. The other type of will is the formal will, or sometimes it's called typewritten will. When you go to the attorney and have the attorney prepare your will, definitely the attorney will not handwrite it. The attorney will type it on a piece of paper. And formal will or typewritten will has to comply with the strict requirements of the law in order for it to be valid. Now, the requirements, there is a testamentary capacity requirement, and there is also the procedural or what we call the formal requirements as to the document itself. Testamentary capacity, of course, the testator is the person making the will. Testator, if it's a male, testatrix, if it's a female, but either way, testator, testatrix, it's just the same, the person making the will. So you're called testator or testatrix. Now, of course, when you made your will, you have to be mentally capacitated. You have to have the required age, like 18 and above, because you can't make a will if you're 14 years old or 16. You must be at least 18 years old. And you have to prove that you know what's going on during that time, that you are making your last will and testament, and you know the bounty of your estate. So that's the testamentary requirement part of it. Now, the formal requirement as to the form. So you know that a formal will has to be typewritten entirely and has to be signed by the testator, and the testator must actually sign in the presence of the witnesses. And this is where errors sometimes happen as to the execution part of that. And we'll talk more about that errors later on, but we're just talking about the requirements of this type of will. So testamentary capacity and the formal requirements. Does it have to be notarized? Well, it is not a requirement for validity of the will. Even if it's not notarized, it's still valid as long as it's signed by the testator and attested to by two witnesses. But it will make a lot of difference later on during probate if the document is notarized and self-proof, because that additional provision there will save the witnesses from appearing and testifying in court later on. So, and that is why it's important for you to talk about that with your estate planning attorney when you start making your will, because it has to be self-proved. And that is not a requirement, but that is a very important part of the will later on. Okay, now, what about, this I don't know if this is happening in real life. I haven't encountered this, but I've seen this in the movie. So there is this person on, dying and making wishes on a deathbed. And sometimes if that person has no relatives and that person was very grateful for the services that the doctor has rendered, and he'll tell the doctor, you've been very good to me, and I am very much capacitated right now. I know what I'm saying, and I am very grateful, and I'd like you to have all my estate. And there are probably 10 witnesses in that room. Is that enforceable in the court of law? Is oral will acceptable in Texas? Oral will is sometimes called non-cupative will. Well, in Texas, that is not a valid will. So if somebody is giving you something orally, please grab a piece of paper and let the person sign. Who knows, that signed paper there may be considered the last will and testament of that person. But oral will, it's never going to happen. So no matter what they say, what the person will tell you, promises, you cannot enforce that in the court of law. So oral will in Texas is not valid. I'm not sure in some other states, but no, that is not enforceable here in Texas. Again, that is called non-cupative will. If you hear that, you will say right away, oops, Texas doesn't recognize that. All right, so brain check again. Okay, here's a question now. Can a written declaration on the back of a grocery receipt signed by me be recognized by the court as my will? Let's say I put there, I'm giving $10,000 to my niece, Amanda, and then I sign it. Can that be considered as a valid will? Yes or no?
Yes, yes.
Yes, and what do you call that?
Holographic will.
Yay, holographic will or handwritten will, okay? By the way, this came, this was asked before. What if I did not date my holographic will? Will that make it invalid? No, it will not. Even if you did not date your holographic will, it can still be considered a valid will because it is not required. But it is important to date it if ever there is a contest later on, or there's another document that will appear. So it's always important to just put the date there, unless you're not sure what date was that time. So, but yeah, it makes a lot of difference later on if you date it, although it's not a requirement, but just do it because you'll never know when it will be helpful. Okay. All right, and I noticed that most of the people who's doing the holographic will are those who are traveling a lot. They don't have a will yet, but they travel a lot. So they write their in case something happened to us, to me, I'm giving all my estate to my children in equal share sign. So that is usually happening because they don't have a will in place. Okay. All right. And I think there's one more question. All right, here we go. I verbally told my doctor at my deathbed that I want to give all my house to my nurse who took care of me. Will the court recognize my wish?
No.
No.
No, because what do you call this will?
Oral will.
Oral will or non-cupative will, and that is not recognized in Texas. I'm not sure which state recognizes that, but not here, definitely not here in Texas. Okay, and I think last question for this objective. I crossed out the name of my husband as my beneficiary in my typewritten will. And I even countersigned it right before I died. Is this a valid revocation? So I guess what happened here is that, so the wife has a will in place and husband is probably the sole beneficiary in her will. And then they probably started a divorce proceeding, but the divorce is still not final yet. So legally speaking, they're still married. And so what the wife did, just cross out the name of the husband and write another name there. So could this be, I'm sorry, I clicked right away, so you already know it's not. Okay, no, it is not, because you cannot just make an amendment or changes on your typewritten will just by crossing it out and countersigning that. That's not how you amend your will. You have to actually execute a supplementary will, or sometimes we call it codicil here in Texas. And that codicil has to actually comply with the requirements of valid will. So it must also be signed by the testator or the testatrix in front of two witnesses, and the two witnesses must subscribe their signature there as well. So it has to comply with the requirement of a valid will, because the codicil can stand on its own. It can be a will by itself. So yeah, you cannot do this. Please don't do this. I've seen wills like this, and I was like, oh no. You're lucky you're still alive. You can correct this mistake. Otherwise, you probably, this is not the outcome you probably want when the time comes. So please don't do this. All right. So we finished the first two learning objectives. Hopefully you understood the importance of having a will, and that you learned the two types of will here in Texas. And somebody is trying to join. Let me admit her. There we go. So now let's go to the third, which is, I think, is important. Okay, so we will explore the common errors in making a will. This is not exclusive. This is just some of the common, some of the errors that I've seen so far, most of the time. But there are more than this. So if you make your own will, think about this. Words are very powerful. As a matter of fact, one word can make a difference. It can change the outcome of your will. It can cost you more later on when the will is probated. As a matter of fact, in this example, it could cause a World War III, I guess, if this is what's going to happen, right? Common errors in making will. One word can make a big difference. So let's explore what are the possible oops that one can make in making a will. Okay, so I created a Venn diagram just to keep it concise, because remember, we have in Texas, we have two types of will. We have formal will and we have holographic will. So there are some common errors that's happening in formal will, and could happen also in holographic will. And the first one is ambiguities, vagueness, words that are not clear. This is happening a lot because, like I said, if you did not use the correct word, it could mean something else. Like as a testator, if you are writing your own will, your intention is probably clear to you, but for the others who are reading your will and you're not there anymore to explain to these people, they might understood it in a different way. So that's where ambiguities is happening, and that ambiguities could cause the provision in that specific provision in your will to be invalidated, or even the entire will could be invalidated. The most common example here in holographic will is the use of pronoun he, she, they. And Filipinos, we use that a lot, but it creates a lot of vagueness in your writing. Just imagine you mentioned 3 names before that, and then all of a sudden in your next sentence you use the word he or she. Who are we talking about here? That could cause an ambiguities in your document, and that is a rich source of contest in a will. And even in formal will, if you just downloaded a will and you probably did not go through each word in that will, there might be some words that are not applicable to you, and it will just make the document vague. So it could cause a part of your will to be invalidated, or even the entire will could be invalidated. So that's just one common error. The other is alternate scenarios. Holographic will, this is happening a lot in holographic will, because sometimes I just write, I give my entire estate to my daughter. Let's say your daughter's name is Helen, Helen Santos. And then you did, after that, nothing else. There's no alternative beneficiaries. What if that your daughter naming that holographic will pass away before you? That means she's no longer existing at the time you pass away, and there's no alternate beneficiary. So then they have to find who is your heir at that time, because there's no named beneficiary. So that could cost much, because they have to find your heirs. And it could be that your will could be probated under intestate succession, meaning to say the Texas will make a decision who's going to get what in your estate. So if you like, and then there could be alternate of the alternate that could happen. You can be very specific. You can go as far as second or third alternate, but make sure to have that alternate there, because that scenario could happen. And it's also happening in formal will, because sometimes if you just download a will and it's just one plain designation of beneficiaries there, and you did not add anything to that, or you did not modify that, then that could be a costly mistake there that will drag the probate of your case for a longer time and more costly. Okay, what else? Naming an executor. No, in your will, you can name an executor, and I have mentioned that one earlier. If you did not name an executor, then anybody can apply as your administrator. And I don't know if I already distinguished between executor and administrator. Executor is a person named in the will to manage your estate. Administrator is when the executor, you have a will, but the executor doesn't want to do the job or is not available at the time, then another person can apply. Then that person is not going to be called executor, but administrator. And if there is no will, then whoever is applying to manage your estate will be called administrator. So if you did not name an executor, or you did not have an alternative executors, then that could be that could cost you much later on. I mean, not you, but your estate. Okay, and administration. And this, I just remember this. I think it was yesterday that I was reviewing a will, and I have to probate that will, and there is no mention of what kind of administration is supposed to be instructed by the testator. There are two types of administration here in Texas. We have the dependent administration and independent administration. If you did not specifically provide independent administration, then the default is dependent administration. And we don't want dependent administration, because all the decision of your administrator or executor will have to be approved by the court. So the court has supervision over the disposition of your estate, and the executor or the administrator will have to ask permission from the court in everything that the administrator or executor will do. So that could be costly and will take longer time to do things or settle your estate. So you have to be very careful. Sometimes the word independent administration is not clearly or expressly spelled out in the will, but we try to analyze the will and see if there is anything in the will that will show that the testator wanted an independent administrator. So we still have to dig deeper into your will if there is that thing that will give us will show the intention of independent administration. That will help a lot when we do probate your will. Okay, so, and of course, signature. The signature requirement is very important. Without your signature, that document has no value. It's not going to be considered your will. And when you, as a testator, when you sign it, you just don't, if it's a formal will, you have to sign it in the presence of your witnesses. If it's a holographic will, just make sure it's your signature and not somebody else. You cannot tell somebody to, hey, sign this for me. But there might be some exception to that, but those could be some special cases. Now, as the formal will, What other error or oops could you make here? Of course, if your formal will is not compliant with the state law, here in Texas, the formality of a will has to be signed by the testator, has to be purely typewritten, signed by the testator in front or in the presence of witnesses. So that means the witnesses are actually seeing the testator signing the document, or at least they are aware that the testator is signing the will, and that the testator knows that he is signing his will, his last will or testament. So an error could happen when there's not enough witnesses. Like Texas requires at least 2 credible witnesses. So if you only have 1, then that's not enough. That will invalidate your will. If you have 2, but the other one, let's say the other one is age 13, well, it's not credible. So then you will have only 1 witness. Or one of the witnesses is a beneficiary of the will, then that will not be considered. So you still didn't comply with the requirement of the law. Okay, because the witnesses must be disinterested witnesses and witness improperly. Just like I said, if the witnesses didn't actually see the testator sign it or was not near the area when the testator signed it, then it's not properly witnessed. And as to holographic will most of the time does not dispose the entire estate. Like for example, you just put there, I'm giving my house to my son, I'm giving my car to my daughter, I'm giving my jewelries to my other daughter. So, but what if you have other specific properties that you did not mention in your will? What if you have a yacht somewhere or in Galveston and you did not dispose that in your will? So then it will be probated under intestate succession. Texas will tell you who's going to get the yacht. So yeah, that could be an error there if you did not dispose your entire will, and this is always happening in holographic will. And of course, bad handwriting. I've encountered this, that the other attorney, the attorney ad litem and myself couldn't agree on what that word means there, because it's really hard to read it. So yeah, that could be an oops there as well. And I understand most of the time holographic will are being done in a haste, because you're traveling or you're about to die and you just trying to write something for your heirs, for your beneficiaries. So yeah, bad handwriting is also a big issue there. And disposing essay that no longer exists. What do we mean by this? So for example, you said in your holographic will, I give my Honda Civic car model 2019 to Maria. And at the time of your death, you no longer have that car because you already sold that. Instead, you have a Toyota Camry. So then that Toyota Camry is not going to replace that missing car already. It's not. So that means that car that is existing at the time of your death will have to be distributed according to Texas. So yeah, that could be a big oops there when you're trying to dispose asset that no longer exists. And there's another thing, of course, the beneficiary will probably say, well, since that car is no longer existing, I can have the new one. But that's not what it says in the holographic will, so that could not happen. Okay, so those are just common errors. There are more, and sometimes they're just very simple that you tend to overlook, like, okay, that is not that much important. Like, for example, the word and, where did you put the word and? Where did you put the comma? So that it will make a lot of difference as to the meaning of the words or provision in that will. So those are just some of the common errors. Now, let's see this one in action. Okay, I have here an example of a will. Can you all see the will? Can you all read it? Yes?
Yes.
Okay, correct. So what kind of will is this? Anybody?
Is the holographic will?
Okay, this is most likely holographic will, assuming it's handwritten by married now. Married now. Okay, so it's dated and it's titled My Last Will. So that means she knows that she is making a will. That is your testamentary capacity there. And let's say married now is 18 years old and above because she made a will. Okay, so assuming she is capacitated. Now let's read the first line. She said, I'm married now, make this last will. So that's a good one. It's clear that she is making a will. Let's go to the second line. I give my entire estate to daddy. That seems okay, right? That seems okay. She's giving her entire, and it's not just a part of the estate, but entire estate to daddy. Now, she also mentioned here, if daddy passes before me, so she's making an alternate scenario here. If daddy passes before me, I give my entire estate to Annie and Benny. So there are alternative beneficiaries. So it looks okay, right? Because she's trying to make an alternative scenario. And then she went on and say, and wrote, I give my diamond ring, and she's very specific, diamond ring, to my favorite cousin Jan. Okay, so that is an example of specific bequest because it is a specific item. And then I leave my car to my good friend Terry Smith. Now, just ignore the fact that there's no period, there's no comma in this will. But pretty much, do we understand her intention here, the meaning of the will, right? And she signed it. So this could pass as a valid holographic will. Is that
Isn't there
right?
a conflict?
What about
Isn't there a
this-
conflict there in the last will? Because she says I give my entire estate, but then she says at a later time that she gives her diamond ring and the car to some other people.
Yes, that could be
Isn't that contradictory?
that could be a contradictory, but we can also interpret this will as she's, because in under the Texas estates law, we always give the specific item first. So real property and personal property first before we dispose the rest of the estate. So what she's trying to do here is she's trying to make a specific bequest, which is the diamond ring, so that has to be given. And another specific bequest, which is the car, so that has to be given first. And whatever is the remaining, that will constitute the residue of her estate. So that could go to daddy. If we are going to interpret this based on, when there are contests and it includes a specific bequest and general gift and residue. Now, so we said that this could be a valid will in Texas. We said that this is a holographic will, and that is correct. But, and you probably already know the answer here because you already made comments that, oops, there are some vague provisions or wordings in the will. And that's a good application of what you have learned today so far. That's true. This is not a good will because there are ambiguities and errors in there. And some of you already pointed out this possible errors and ambiguities in the will. First, the word daddy. I heard somebody said about daddy. Can you tell me more about that? Why is daddy vague?
It should be named, right? It should be the actual name of the person.
Oh, that would help a lot in understanding the will, because, for example, let's say, for example, married now is married at the time she passed away, and she maybe, well, I don't know if this is a Filipino thing or it's just me, that we model to our children. We call our husband, daddy, so that everybody else, all the kids will call daddy. What if there's the daddy who is the husband and there's the daddy who's the father? So now this makes it this is now, this provision of the will, part of the will, is now vague because we don't know who are we talking about here. Is she talking about daddy of her children or daddy is father? So then that could be contested there. Daddy might say, wait a minute, that's my only daughter there. Maybe that, and we have good relationship, so that's probably for me. So, and then husband will say, nope, because you know, you're no longer part of our daily life and you live far away. So that daddy there is me because she calls me daddy. So that is a rich source of contest there, right? Okay, what else? Let's see. This phrase, my favorite cousin Jen. How could this be a possible ambiguous, vague provision here? When can this be? Is this not clear enough? Why could this be?
She could have another.
Problematic.
She could have another cousin named Jen. And
Perfect. Yes. What if there are more than one Jen? And it doesn't matter if that's her favorite cousin. That is very subjective. You know, all the Jens can say, you know, I'm the favorite cousin. So yeah, so it's not very specific. I mean, it would have helped if there's a last name, but it could also be vague if there are two of them. So it could, more specific description will help a lot in avoiding contests later on. Okay.
That also applies to Annie and Benny.
Yes, Annie and Benny. Who's well, I give my entire seat to Annie and Benny. And who are these people? There could be Annie, niece, and cousin, and friend, right? And also Benny. Or this could be pets. I don't know. So, yeah, but that could be a good source of contest there. And I did not, I don't think I included one, but that is a good one too. Now, here's another one. I leave my card to my good friend Terry Smith. How can this be a possible source of ambiguities here?
Yes, she might have another car or two cars.
That's right. What if she has more than one car? Which car will go to Terry, to friend Terry Smith, right? Of course, Terry will probably choose the more expensive one, but will the other beneficiary probably will not agree to that. So this is another area where in provision in the will that could be subject to a contest. So it looks simple. It looks like, okay, this is good. I did a good job. I'm pretty sure I've covered everything. But look, it could be contested, and it could be the entire will could be invalidated, or most of it could be invalidated, and she will end up, you know, as if she died without a will. So. And that's what we're trying to avoid. That's why we need to know how to make a proper will. Okay, now here's the thing. This is very recent, and Orly and I were talking about this early this year. Larry King, very famous, very wealthy person, and look at his holographic will here.
Oh my God.
Well,
and he's rich.
And he's rich. Well, let me give you the background here. Larry King was married to, I don't know, wife number, is Sean wife number 7 or number 8? Because he's like married for how many times already? Okay, well, assuming she's the 7th wife, because I don't have that information ready here. I will probably remember that later on. But yeah, so Larry King has a typewritten will. That's dated 2015. He made the will in 2015. That's the one here in red ink. So, however, after he made that will, he and his wife, current wife, Sean, initiated a divorce proceeding. So they're divorcing. They were in the process of divorce when he passed away last January. So the divorce is not yet finalized. So legally speaking, Sean was a surviving spouse of Larry King. And in that 2015 will, he named her as the executor. So she will be managing the estate of King, and making sure that the estate will go to the right beneficiary. Now, however, so King became very, very ill, and in October 17, 2019, he made this handwritten will. And it makes sense why it's so hard to read. It's because I think he's already kind of bedridden at the time. Most of the time he's just on, but we don't know his mental capacity at the time, because there is a contest to this holographic will, because Sean is assailing or trying to declare this holographic will. By the way, the holographic will is the most recent will. So most likely this is the last will and testament of Larry King, and that means if this is the last will and testament of 2015 is revoked, right? So whatever he wrote here should be followed as to the distribution of his estate. And in this will, handwritten will, let me show you, I think the next slide shows a bigger picture. Yeah. So he dated it, he signed it. As a matter of fact, it's even witnessed. Well, remember, this is in California. So California law is different from Texas, but holographic will in general is just the same as our holographic will here. It has to be entirely written, and it has to be signed. So this could be a valid will in its form. Now, what in this will, he did not give anything to the wife, because they're already in divorce proceeding at that time. So he's giving his 100% of his estate to be divided equally among his 5 children. Andy, is it Shania? Larry King Jr., Chancey, and Cannon, I think. But Andy and Shania, if I am saying it right, predeceased him. So they passed away before Larry King passed away. So basically, or legally speaking, he only has 3 children living at the time of his death, and that's Chancey, Cannon, and Larry King. Okay, so yeah, and this is in dispute right now, because of course the wife Sean is trying to have the handwritten will invalidated, assailing that Larry King at the time was not in the right frame of mind. He's very ill. He was probably influenced by Larry King Jr. So those are her arguments. And because if she gets this invalidated, then the 2015 will be probated. And of course, it has different disposition of his estate, and definitely wife is in that will. So of course, she's trying her best to have it invalidated, but it's still in dispute. We don't know. I'm not, as of this time, I don't have an update of who's winning. I'm pretty sure this is going to drag for a while because it involves big estate, big wealth. And aside from the fact that Larry King has a trust that disposes big chunk of his estate, so but the rest of his estate, the residue is still big. So yes, this could be a very long litigation. And also as to the claim of the wife Sean, that Larry King, she's saying that Larry King Jr. was never he never existed until he was about 30-ish years old already. So how could that be? How can Larry King give a big chunk of his essay to a son who did not exist in his life for 30 years? And so she's saying that there is an undue influence, and well, that could easily be assailed, because how can there be an undue influence if Larry King did not, if it's true that he did not establish a good relationship with Larry King Jr., so why would he be influenced by him? So yeah, it could be a very long litigation later on. Okay, so yep, that could happen, but it's hard to read his handwriting, right? So at first I was like, okay, why only a holographic will? It makes sense. It's already probably dying at the time, or he knows he's about to die, and because of the divorce, he tried to correct his mistake, which he did before he passed away. But it still um, uh, could still be source of litigation because there was a will that existed before that. So yep, there's the family. And so these are my probably the words that I really want you to think about. As a probate attorney, I've seen some actions in court that it's really not it's not very pleasing, especially the two parties there who are fighting are family, and they belong in one family. Could be extended family, but still, there's that bloodline there. Now, it's hard to see that probate court is now it has become the final arena or battleground for, I put here, dysfunctional family, where they expose the darkest secret of their family just to make a point, just to get something more from the estate. Family members bring out their revenge, sometimes for mom and dad, just because parents give more give the other sibling or I don't know children more than what the others receive. So it's very personal, but and so that's why I said a will is probate of a will is or a will itself is a personal matter and also a legal concern because of this legal issues that could arise later on. And it costs more to contest and fight it out in court, and they know that, the family members, they know that, but they still do it. Why? Why do they do this? Just to prove who is right, instead of just settling the issue with each other. And I get it. Their family dispute is the hardest dispute to settle because it's personal and it's most of the time deep. So it's just sad to see family fighting over the estate of the deceased person instead of focusing to the person who just passed away, the loved one who just passed away. So, and it's hard. You're grieving and at the same time dealing with this legal battle in court. But you can spare them, and you all know how to do that. So let me go to my brain check here. Okay. So now that you've heard and listened and think you are now familiar with the will, the types of will, the reason why we have to have a will, why is it important, and that the time is now. Are you thinking about making your will now?
Yes.
Good, because if not, what is holding you back? What is it that is holding you back? Is it because of the time? Is it because of motivation? We discussed them earlier. What is holding you back for not doing so? But whatever it is, it must be more important than your loved ones because they're not your priority. It is in your loved one's best interest to make it a priority. There is no perfect time. There is no right time. Now is the time, according to our meme a while ago. Now is the time, because what if there's no next time? And that is my presentation for tonight. Thank you. And if you have any question, we have time. Sorry, I told you it's more than 1 hour.
Can I ask a question?
Yes. Yes. Let me stop sharing.
I had a will prepared about 10 years ago.
Yes.
If the state of Texas changes the requirements in a formal will, do I have to change my will? Do I have to update my will?
That is a very good question. Now, as to formality, whatever is the law at the time you made it, that is what is controlling at the time. So if you complied with the law, let's say, for example, 10 years ago, there are these requirements and you complied with that, then the will is still valid. Now, as to when are you going to think about amending it, changing it, if you have so changes in your circumstances, like for example, and I'm gonna say this because I think I mentioned it earlier. Like for example, you got divorced, so that means definitely your wife is no longer your heir or beneficiary. So you have to update your will. Otherwise, that could be a source of contest later on. The other thing is, if you, let's say, for example, you made a will right now, then and then you're remarried, so you have to update your will, because in that will that you made, your spouse was not existing yet. So in that will, she's not, or he's not going to get anything under your will. So definitely the spouse is not going to be a beneficiary. Also, minor children, if you have minor children now, and when you made your will, definitely you most likely designated a guardian, or you put up a testamentary trust there. Now that they're no longer minor, you have to update your will as well, because they no longer need the trust, they no longer need the guardians, because they're already more than 18 years old. So if you have major changes in your circumstances, then I would suggest you revisit your will. I'm not saying always, like change your will every other 3 years, no. But if there is a major change, please update it, because it feels, it's so hard to see people, it's like a pretermitted wife. I really feel for them, because the law says they're not going to get anything under the will, even though the husband loved her so much and wanted to give her everything, but the will says otherwise, and that will was not updated, then the wife is pretermitted. In Texas, there's no such thing as pretermitted wife, so the wife is not going to get under the will. But it's different when it's a child. If the child is not existing at the time the will was made, and then the child was born later at a later date, then the child is considered pretermitted child, and pretermitted child is protected in Texas. So that child, it will be considered an heir under the will. So that child will get what the other sibling might get, well, as if the testator died without a will. So he'll get from the parent who passed away. So yes, please revisit it. And there's no perfect time, like I said, you'll never know. So just make sure that when you try to do it yourself, please be aware of the ambiguities and errors, and be very careful with the words that you're using, because if there is a contradiction, that provision of the will might be invalidated, or the entire will be invalidated. So good question.
Thank you, Aileen.
Eileen, question?
Yes.
All right. If we have properties in the Philippines and we have siblings in the Philippines, and will this will that we created in the state of Texas, will that hold water in the Philippines if that particular inherited property is being subject to issue or being contested by some of the siblings in the Philippines?
Okay, so the property is located in the Philippines?
Yes.
Okay.
The will is created in
And
the state of Texas.
and the will is made here in Texas, and there are properties here in Texas as well?
Yes.
Okay, that is a very good question, and I get this question a lot. Like most of the Filipinos have properties in Texas and in the Philippines, so that is mostly their concern. If you made your will here in Texas, and your will is in compliance with the requirement of Texas law, then it's valid here in Texas. Now, Philippines will recognize that, because Philippines follows, if it's valid there, it's valid here. So if it's valid here in Texas, that will is also valid in the Philippines. So you can actually include your properties located in the Philippines in your will here in Texas. Now, as to probate, it can be probated, of course, if the will is made here in Texas and the property, and there are properties here in Texas, you will definitely probate that will here in Texas, right? And if it's properly probated and the court declared that the will is valid and appointed an executor, Philippines will recognize the probate here if it included your property in the Philippines. That means you do not have to probate the will again in the Philippines for the Philippine property, because the court there will recognize our probate here. Of course, there's an additional step to that, like bringing the court order here and be recognized by the Philippine court in the Philippines, of course. So, but yes, you do not have to probate that in the Philippines, but you can if you want, because sometimes you have a separate document. Sometimes you have this main will, and then that disposes your property in Texas, and then you have a supplementary will or codicil that disposes your property in the Philippines. So you have a choice to probate that here or probate it in the Philippines. But if it is just one document and it's just one will, and it included the properties in the Philippines, you can just have one probate here in Texas and have that probate be recognized in the Philippines. So you do not have to probate the property in the Philippines. Follow-up question?
One more, attorney.
Yes.
Do you normally include medical directives in your last will and testament, like do not what you call resuscitate order, DNR, or
directive to physicians?
uh,
Actually, those documents are part of the estate planning document, but those documents like the medical power of attorney, the durable power of attorney, direct documents, and they are documents that are enforceable while the person is still alive but becomes incapacitated. But the will is a document that is enforceable upon death. So you see the difference? You're still alive, but you're incapacitated. Those medical power of attorney, durable power of attorney. Excuse me. And for me, when I do my estate planning, it's included. Okay. I need to drink water. Any more questions? Sometimes I make 7 to 8 documents for estate planning, just the important basic documents that a person needs to have at this point in time. Like I said, the will and the disposition of remains, those are documents that are very useful after death, but the rest are useful while you're still alive but incapacitated. Like, for example, durable power of attorney, you are assigning an agent to take care of your assets, your properties. The medical power of attorney, you're assigning somebody as an agent to take care of the decision as to your medical condition, medical treatment, because you can no longer make a decision for yourself. Disposition of remain. Sometimes you put in your will how you want your remains to be disposed, but I always make a separate independent document for that, because if the will can't be found or it's not yet done being probated, your body is not going to be waiting for that, right? What if it took about 2 months before the probate terminate or finalize? Then your body will be waiting. So that's why we have an independent document for disposition of remains, which is also referred to in the will. So that's how important it is, because sometimes they ask, why do I have to have a separate disposition of remains document if I can already include that one in the will? And that's my answer to that, because sometimes it takes a while, and if your buddy is waiting for 2 months already, that's not a good thing. So you have to have your separate disposition of remain document. Any more question? Marina, Leah,
I have a question.
Sheldon? Yes, who is it?
So,
Let's change this one too.
we also
Speaker.
had a will made before we went for our Europe tour back in 2010, I think, with my kids were minor then. So we had,
I think it got changed due to stroke.
hello?
Yes, Leah, go ahead.
So I think you mentioned that if we have to have a major change since our children are now adults, they're 22 and 19.
Yes.
In our will, we had like guardians, like my sisters, who will take care of whatever we're going to leave behind. So we're gonna have to do that change, right? And this was written in Alaska also.
In the
Due to stroke.
last will, in your will. Yes, you have to update a one because that will is no longer
Valid.
useful for. Yeah, and then it's not going to be useful anymore. It will not make any. It cannot be imposed anymore because the children are already adults, so they can make their own decision. And it might just create confusion later on. So yeah, just update that one and take out that provision. And if you also included a testamentary trust for the kids, you might want to take a look at that too, because you might not need that also. So yeah.
And also, hello.
Yes, go ahead.
Sorry. I remember during our convention here in the Woodlands, Texas, and there was a presenter before, and it was almost kind of will, but they're talking about something else. And the takeaway that I got from that class was, my will is not enough. What other type of legal document was that? I think that's something like when you are still alive.
Yes, that's probably what they meant about that, the ancillary estate planning document that I have mentioned earlier. So when I do my estate planning, the basic documents that I prepare are actually around 7 to 8. Those are the essential. So the last will and testament is a major document, and then the durable. I think you're talking about the durable power of attorney, the medical power of attorney, the directives to physician. Directives to physician, that's the when your condition becomes irreversible, or that there's no cure anymore, and you have to. They have to make a decision later on as to whether to pull the plug or not. And that's going to be a hard decision for your family member. So you can already make a decision before that time happens through your directive. So, and sometimes we call that one living will in Texas, but it's really the directive to physicians. And it's very specific. It has to comply with the required format under the Texas Estates Code, and the code updates it sometimes after 3 years, so it depends. So they take away, they add some provisions, so you make sure you have the most updated one if you are going to make it on your own or by yourself, because it could be invalidated if it didn't comply with the requirement of the law at the time you executed it. So yeah, like the other document could be HIPAA authorization, and you know how important it is for your loved ones to have that authority to get those information. So you need to have that as well. And I also include declaration of guardianship in case or before you become incapacitated. And this is for you, not for your children. This is for you, because in Texas, because I do guardianship. And let's say, for example, you become incapacitated, either temporary or permanent. And even if you have a husband or a wife, you have a spouse, your spouse can't make most legal decisions for you unless he gets a court order through guardianship proceeding. And there are two types of guardians: guardian of the person and of the estate. So your husband might qualify as guardian of the person, but might not qualify as guardian of the estate, because there are two different, they have different qualifications. And the reason why there are different qualifications, because the guardian of the person they will make a decision as to your personal care, like where will you live, what will you eat, what are the activities that you can do and cannot do. But for the guardian of the estate, it's all about managing your assets, your estate. So the law is very strict as to the requirement, because if the person is disqualified, then he's not going to get that court order. For example, if that person has a history of arrest involving moral turpitude, like theft, falsification, forgery, that person is disqualified to be a guardian of the estate. And it makes sense, because that person will be managing your money, your property. And yeah, like for example, Britney Spears, the long battle of the issue between Britney and his father. So even if Britney is already at the right age, pretty much the father is still in control. But I'm not sure. I don't have the update right now. But yeah, it is a battle between Britney and the father. So, like I said, if the person has guardianship over a person, that person can make a decision as to either the person or the estate of that person. And I don't know if you watched the movie I Care. I don't know if that's in Netflix. That is very,
I did.
Although it's not entirely, correct, because if you're an attorney and you're a probate attorney or guardian ad litem attorney or guardianship attorney, you will know that there are probably some exaggeration there, but in general, the concept is real. I mean,
is that true? I mean, that someone can just take your assets and put you in a old people home?
Okay, so yes, that could be, that is true, but of course there are strict requirements of the law, which it was not discussed, or it was not really shown in the movie. But it's true, anybody, and that is why you need to have that document, that declaration of guardianship for you before you become incapacitated, because basically it could be anybody. It could be a person, a random person, somewhere there, who's interested in your asset or in your person, as long as that person is qualified and there's no other person who applies for guardianship as your guardian. Then who will the court appoint? Whoever is applying as your guardian. And if that person is qualified, then the court will appoint that person. And that is sad if you are not prepared for that, because just imagine a totally a stranger having control over your person and over your estate. But of course, that movie is a little, that's
is it exaggerated?
It's exaggerated. It's not as easy as that. I'm just saying, because as a guardian, you have to, of course, submit, have whatever your decision is, have to be approved by the court, and the other relatives can contest that. So it could be a litigated matter as well. And I have a recent case about guardianship where the spouse is representing the spouse who is applying for guardian over the person of her husband. And it's a fight between the son in the previous marriage and the wife. who is physically separated. So it's not it's not easy to mediate. It took us about we had like a half-day mediation on that one, and we still didn't settle the issue because no one wanted to say, okay, you can do it. No, it's always, I want to do it. I am more qualified than you. I am more concerned than you. I can take care of him than you. So it's always like that. So now the court will have to make a decision who can do the better job. So the court will look into a lot of factors like your work, your record, of course, your background, your criminal background, your work, where do you live? If ever you're going to be the guardian, who's going to take care of the ward if you're at work? So it's a little more complicated if it's a battle of who's going to be the better guardian. So it's always better to have your wishes there, who you want to be your guardian, because the court will prioritize that. That document is not the court order yet, so you still have to bring that to court and have it head of a court order declaring you as the guardian. But it is, the court will prioritize whoever is your personal choice there in that document. But if you don't have, then it could be anybody. That person could be anybody. Okay. Seeing myself.
I have just one last question, okay? These details, I'm just wondering if the signatures change due to medical reason, and I'll be making an amendment. Is it addendum? Is it still valid? Do you think?
So okay,
it will be different from the first 10 years ago.
Your signature?
The signature.
Yeah, because
okay. So you changed your signature already.
No, because of due to medical reason, he got a stroke. Then he did an addendum. Then we need to sign it. So the signature will probably be different from the
original,
latest
the existing.
Well, what I can say is that could be a source of contest if ever, but as long as you can prove that,
that's what.
Then that will not be a problem. It's a matter of proving it to the court that this was your signature at the time, and if you have witnesses who can testify, then like I said, it could be a source of contest later if somebody will contest your will. But of course, that's why there is a requirement of witnesses. That's important.
Thank you so much. Okay.
Welcome. Okay, so it's already 8:59. I told you this is, and I'm very passionate about talking about last will and testament. Aside from the fact that that's what I do, it's also, I feel like this is a very important document that a lot of people they tend to ignore it because they feel like it is not a necessity, it's not a priority, and they're too young to think about that or too healthy to think about death. But death is uncertain. You will never know. It's certain to happen. You just don't know when. So the uncertainty is when it's going to happen. But the certainty there is that it will happen. You cannot escape that. So just want to let you know that it's always better to be prepared before this.
Thank you, attorney.
All right. Well, thank you so much. And I shared the material, and I will save the recording and share it later on, so you can watch it later on. But
Thank you so
don't,
much.
Just don't distribute it, I guess. Okay.
One last word. Thank you so much for your time and sharing your legal expertise among us. And ladies and gentlemen, you know who to go if you have some issues with your last will and testament.
Yes.
Thank you so much, and have a nice evening.
Thank you, Aileen.
Thank you.
Bye. Have a good evening.
Bye.
And,
Okay.
How do we get the recording?
I'll save it first and then I'll share it with Tito Bird, and I think Tito Bird will distribute it.
Okay, so I can watch it with my husband.
Thank you
Okay.
so much.
All
Thank you.
right, so I'm up to
Okay.
ending now. Thank you.
Do not forget to log in for